So, today we're going to dive into a pretty wild story. It's about a legal battle that's been going on for over a decade, all centered around a child support debt that, well, according to court documents, might not have even been real to begin with. This is a story about what happens when a system seems to fail, when jurisdictions get tangled, and what one person did to fight back. It all starts with this one absolutely staggering number, over $173,000. Now, this isn't just some random figure. This is the total financial harm that was calculated by a forensic audit submitted to the court. We're talking alleged overpayments, payments that were never credited, and collections that were supposedly unlawful. And this quote, which comes directly from one of the legal filings, really gets to the heart of the matter. The argument here is that this wasn't just a simple clerical error. It was a mistake that was allegedly ignored over and over for years until it grew into something much, much worse. So that leads to the big question here, right? How on earth do you overpay, massively overpay, on a debt that court filings claim never legally existed in the first place? To figure that out, we have to go all the way back to the beginning. All right, Section 1, the order that wasn't. You see, the whole thing, this entire decade-long mess, it all hinges on one single piece of paper, the original court order. And the petitioner's entire argument is that this foundational document was legally void right from the start. Okay, so check out this timeline because this is where it all starts to unravel. June 9th, 2015, a hearing sets the support amount. Totally standard. But then, the very next day, the court's own records say something happened, or rather, didn't happen, that should have stopped everything in its tracks. But it didn't. Enforcement just kept going for 7 years, leading up to this really bizarre entry in 2022. And here it is. This is what the filings call the smoking gun, the exact text right from the court's own official record. The court itself, in all caps, stated it was unable to enter the order. So that raises a pretty massive question. If no order was ever entered, what exactly was being enforced for nearly a decade? And this is where a really important legal term comes into play, void ab initio. It's Latin, and it means void from the beginning. The argument isn't just that the order was flawed or could be challenged, it's that it was never legally valid, not for a single second, right from the absolute start. Then, get this, 7 years later, this thing suddenly appears in the court records. It's labeled a child support order, but it has no judge's signature, no document attached to it, nothing. The legal filings allege this was basically a phantom entry, an attempt to retroactively create a legal basis for all those years of collections. But believe it or not, that allegedly invalid order was just the beginning. The filings argue that this first critical failure set off a whole cascade of other mistakes, a domino effect of financial and jurisdictional errors that just made everything worse. So one of the biggest errors they point to has to do with some simple paperwork. The custody arrangement was for shared care, which under Colorado law requires using what's called Worksheet B. But instead, the agencies allegedly used Worksheet A, which is for sole custody. This one switch dramatically inflated the debt. And the filings suggest it wasn't an accident, pointing to emails where officials seemed to know it was a shared custody situation. Any financial hit from just that one change? It is absolutely staggering. You can see here the enforced amount was over $1,000 a month. But according to the audit, the correct amount, by law, should have been around $200. We're talking an alleged overcharge of $50,000 to $70,000 or more just from using the wrong form. And if that wasn't enough, there's another major rule that was apparently just thrown out the window. In Colorado, when a child is adopted and receives state assistance, there's a mandatory cap. The child support can't be more than that subsidy payment. The audit claims this rule was just completely ignored, which jacked up the alleged debt even more. This is where things get almost kind of absurd. When the case crossed state lines, it seems to have fallen into what the filings call a jurisdictional black hole. You have Colorado saying, hey, we're just doing what South Dakota asked us to do. And then you have South Dakota saying, whoa, we have no jurisdiction here. It became a cycle of finger-pointing where, allegedly, no one would take responsibility for the mistakes. So, we've talked about the legal stuff, the paperwork, the numbers, but now we need to talk about what this actually did to a human being, because the consequences laid out in the court documents are just devastating. 527. That's not just a number. According to a sworn affidavit, that is the number of days the petitioner was documented as being homeless. And he links that situation directly to the agency's actions, especially their decision to suspend his driver's license. And the damage just kept piling up, like a terrible domino effect. His license was suspended, so he couldn't work, which meant he couldn't get housing. A clinically recommended plan to reunify with his family was allegedly sabotaged. Collections supposedly kept coming even after he received a written waiver of the debt. And to top it all off, he was getting hit with negative credit reports from 2 different states for the very same debt. The affidavit calls the license suspension a punishment for poverty. And that phrase is a direct shot at a major Supreme Court ruling, Turner v. Rogers. That case basically says you can't just take away someone's license for not paying without first checking if they actually have the ability to pay. To do so, the argument goes, is a violation of their constitutional rights. Okay, so after a decade of hitting brick walls, the petitioner did something completely different. He decided to build his own weapon. He developed a piece of software with one of 2 goals in mind, either prove he was right or give the judge enough evidence to show he was crazy. He was going to use technology to fight the machine. He built a custom AI legal audit system. The idea was brilliant in its simplicity. Take all the evidence, a decade's worth of documents, emails, financial ledgers, and feed it into a system that could turn the agency's own data against them, building an ironclad case. So you're probably wondering, how does this thing actually work? Well, first, it just sucks in all the evidence. Then, what he calls an AI council, basically a team of specialized AIs, audits the data for specific legal screw-ups. They check each other's work to make sure it's accurate, and then, boom, the system automatically generates comprehensive, evidence-based legal arguments. And it's not just one AI, it's like this whole team of specialists. You've got one AI that does nothing but scan for that original signed court order, the ghost order. Another one is an expert on the complex interstate laws. There's even a reviewer AI that quality checks everything. And on top of it all is a governance layer, an ethical check to make sure the whole analysis is grounded in principles like due process. And the result? I mean, just look at this. It's a complete game changer. A forensic legal analysis that would take a human lawyer or paralegal over 40 hours of grinding work, the AI system can knock out with documented proof in less than 5 minutes. Which really leaves us with this final, pretty powerful question. When the very systems that are supposed to ensure fairness and uphold the law allegedly fail this badly, can technology, in the hands of one determined person, become the last and best tool we have to enforce our own basic human rights?